Our next topic is Canadian cross-border investigations and securities enforcement, and who better to speak on that than Sean Boyle of Blakes in Vancouver. Sean's practice involves all aspects of commercial corporate litigation with an emphasis on securities law and business law disputes. His trial and appellate experience in commercial litigation matters includes contested merger transactions, takeover bids, plans of arrangements, shareholder litigation, dissent proceedings, contract disputes, negligence claims, and defending class actions. Sean also advises investment dealers on matters of regulatory compliance and has represented clients in regulatory investigations and hearings conducted by the British Columbia Securities Commission and other provincial securities commissions, the Investment Industry Regulatory Organization of Canada, and the Mutual Fund Dealers Association of Canada. Please welcome Sean Boyle.
Good morning. This morning, I'm pleased to be here in New York. I'm going to be talking about Canadian issues, and Canadian issues that are hopefully relevant to you, your clients, your business groups. Of course, there's been a tradition of cooperation, both at a regulatory level and at an economic level between our countries. This morning, I'm going to be covering a number of issues. It's really a potpourri of issues. And how I came up with the different topics was these are issues that I've dealt with U.S. attorneys, U.S. clients in the last year. So whether speaking with attorneys in Los Angeles, St. Louis, Atlanta, New York, these are some of the things that have come on the radar screen in dealing with those clients. International cooperation is not new. Both the U.S., Canada, and a number of other countries are subject to a number of memorandum of understandings, MLATs, and other agreements. Members of IOSCO, and which provides for cooperation. This isn't a new thing, but what's new, in my view, is the speed and the breadth and the frequency of the cooperation between certainly the Canadian regulators and the U.S. regulators. I'm on the West Coast in Vancouver, British Columbia. It is a very common matter now to have on our regulatory investigation orders. The investigation order would specify the scope or the breadth of the investigation. To have U.S. SEC attorneys listed on the investigation order, to have SEC attorneys want to participate, physically be in Vancouver, British Columbia, and participate in those investigations. And of course, and I will get to it, some of the implication that has for the clients. As you're likely well aware, the SEC is authorized to conduct investigations on behalf of foreign countries. There doesn't have to be a potential violation of U.S. law that the Securities Exchange Act provides that they may provide that assistance. This is relevant because you or your client or your business group may be contacted in a typical fashion by a Canadian regulator. And some of these phone calls that I received from U.S. attorneys are, Sean, I've just received a call from the Manitoba Securities Commission. What is that about? Do they have jurisdiction? How does this work? And the short answer is, for a number of the broker-dealers, the bank-owned financial firms, is that the Canadian regulators don't have jurisdiction simpliciter over you to compel you to produce those documents. But what they do have is they have the leverage of all regulators that if you don't cooperate with the Canadian regulators, and to the extent you have a subsidiary or an affiliated or even sometimes a parent company in Canada, there may be repercussions for those affiliated companies, both parent and subsidiary. And of course, if you don't cooperate voluntarily with the Canadian regulator, then typically what happens is the company will receive a demand, a summons, a requirement from the SEC acting under the Section 21 or the other applicable regulations. And so that is something that comes up quite often. The last point on this slide that I wanted to make is you see that the SEC really is focusing on the insider trading, fraud, market manipulations, and the foreign corrupt practices. And I'm going to touch on the foreign corrupt practices. But the other aspect here that we're seeing in Canada, and I think it's largely thanks to the U.S. government, is that there are no secret jurisdictions anymore. That in our regulatory investigations and the matters we're dealing with, the Warm Island jurisdictions or some of the European jurisdictions, there used to be an element of secrecy. And what we're seeing is that is completely gone. One of the examples of the cross-border regulation and cooperation I wanted to talk about is the SuperCourse metals matter. This was a BC company, which was China's largest silver producer. And the shares of SuperCourse, even though it was a Canadian company, it traded on the New York Stock Exchange, but also the Toronto Stock Exchange. This was an interesting case, and it was around the time, you may recall, the Sino-Forest or all the issues with the Chinese issuers. There was a anonymous report prepared by a self-declared short seller alleging a potential $1.3 billion accounting fraud. And so that was sent to regulators across Canada, the primary regulator for SuperCourse, but it was also mailed through the U.S. postal system to their auditors here in New York City. And the result of that connection, really, which was being used, the U.S. Postal Service being used and mailed to the head office, the parent corp, Ernst & Young here in New York, introduced an element where the U.S., the SEC, was prepared to respond with their market manipulation team to move quickly. And what it was a joint cooperative investigation very quickly into this allegation, which caused, based upon the publication of it, caused the market cap to drop by tens and tens of millions of dollars. And so this was an active investigation. Arising out of that investigation, both the U.S. Counsel, Canadian Counsel, and the U.S. and Canadian regulators, there was action commenced here in New York alleging defamatory and fraudulent statements. And so that worked its way through the U.S. courts. A notice of hearing by the relevant regulator in Canada, the provincial securities regulator, the BC Securities Commission, issued a notice of hearing against that company. And so again, it's just another example of how that was the cooperation between the two regulators and the requirement for both the company and the individuals on either side of the dispute to have their legal counsel in both jurisdictions. The epilogue to this case is still being written in the sense that there's now a foreign corrupt aspect to it. SuperCourse, as the largest silver producer in China, is alleged there was a criminal proceeding that took place in China against one of the agents or representatives of the short sellers, the author of the anonymous report. And you may or may not be surprised, the criminal trial went forward in China. It was alleged that SuperCourse and its corporate aspects, individuals, were really the prosecutors in the case, and the individual was put in jail. There is now a new civil action that has been launched in British Columbia alleging essentially foreign corrupt practices, bribing of government officials by SuperCourse, the defendant, and that the company caused the representative of the author to be incarcerated in China. So it's quite a fascinating case. The increased border cooperation is important to you and your clients if you have any aspect of your business touching in Canada. And the Strategic Global Investments case is a recent case of a Chicago-based investment firm that, although fully licensed and operating under the applicable laws in the U.S., had clients in Canada. And it doesn't require any number of clients. The fact is they had clients in Canada. They weren't registered. There wasn't applicable exemptions available to them. And as a result of that, and in this case, it was a little more egregious than that. There was some issues as to the misrepresentations and the conduct of the individuals. But this company found themselves subject to regulatory proceedings in Canada. Likewise, in the Quantum Minerals case, we again had residents of Texas distributing securities to Canadian residents without the appropriate exemptions or registrations. And again, without that, it raised regulatory issues. For those of you, and people have mentioned here today about the trial.com website, I spoke last year on the issue of jurisdiction and how the Canadian courts and regulators have really an expanding role of jurisdiction, and so I won't go into detail, but I commend that to you. And we're seeing it as really the opposite of what the U.S. Supreme Court in Morrison is doing, is that there's an expanding role. And so, for example, there's another case that's ongoing against a lawyer resident in Singapore, her brother, who is a resident of Hong Kong, involved in insider trading. And the only connection is, of course, that the issuer was a BC or a Canadian company. And so what we have is the Canadian courts and the Canadian regulators taking a really broad view of jurisdiction. And so it's something to be alive of when you're advising your client or reviewing your business group's business. One of the reasons it's such an issue, and one of the very live issues in the Canadian courts right now is there's a constitutional challenge being brought, is the risk of self-incrimination. Securities regulators in Canada have an extraordinary ability to compel documents and testimony. That's not new to any of you that practice involving the SEC. What the difference is in Canada, we do not have the right to remain silent in administrative proceeding. We don't have the ability to exercise a Fifth Amendment right. But the procedural safeguard our Constitution provides is that if you're compelled, either as a corporation or an individual, to provide testimony and documents in a regulatory administrative matter, there is use immunity. There is derivative use immunity, meaning that testimony, those documents cannot be used in any criminal proceeding. And so that's the safeguard that's available in Canada. The problem is that use immunity, derivative use immunity, is only available in Canadian criminal proceedings. And so what we have is investigations, joint investigations, where the SEC is involved, the DOJ is involved. You have this compulsion power available by the Canadian securities regulators, and that information can't be used in any Canadian criminal proceeding, but under the applicable MOUs or MLATs, that information can be shared with the SEC, or it can be shared with the other foreign regulators in the UK, for example, and that information may be admissible in a US criminal proceeding. And so that's a real live issue, that there appears to be a gap, and it's currently before the courts in Canada right now in the province of Alberta, where the defense counsel like myself would say, surely it can't be the case that neither the Canadian constitutional protections or the US constitutional protections would apply. One or the other have to apply. And so how it's being dealt with in the Canadian courts is defense counsel like myself are having their clients exercise Fifth Amendment rights. And then the Canadian security regulators say, well, you're in contempt, and you go to court. They are taking respondents to court in a contempt proceeding, and so that's currently being adjudicated, and it remains to see how it plays out. The next topic plays into that, and it plays into the securities regulators, is that what we're seeing in Canada is a very significant increase in investigations for corruption of foreign public officials. And again, that's one of the aspects under the SEC's acknowledgement that they want to assist. We have 35 investigations are ongoing. Traditionally, Canada's been very lax in connection with foreign corrupt practices, but it's a very live issue. It's a significant issue out in British Columbia where I practice because of our mining, natural resources, oil and gas clients that are doing business in Africa, in Asia, and other countries. It also applies to our bank clients, our financial clients, where they're being involved in that investigation, not as a target of the investigation, but as witnesses, as they're being compelled to produce documents and information about their clients, and going forward with that process. This is an example of where the risk of self-incrimination comes into play, because you have potentially a joint investigation, and people, when they're responding to those compulsion orders in Canada, want to ensure that they're not going to face any jeopardy either in the US or in the UK, which is another jurisdiction that's aggressively pursuing it. I've included a number of slides in the materials about the corruption laws in Canada. The one point to highlight is that recently, in June of 2013, there's been amendments to that, which makes, we now have the books and records offenses like the US, and we are eliminating or making illegal the facilitation payments. But that subject matter is worthy of a presentation all on its own. This two more topics to get through this morning, and this next one is the enforcement of SEC judgments, but of course this applies more generally. But a lot of the questions I get from US attorneys is, are SEC judgments enforceable in Canada? And the short answer is typically yes. Orders for penal sanctions are not, but there's really a plethora of case law now, and most recently from the highest court in the land, in the province, BC Court of Appeal, confirming that civil judgment or disgorgement orders from the SEC are not penal in nature, and therefore they are enforceable, assuming that the judgment was obtained through in compliance with natural justice and public policy, there was notice, and so on. Finally, one of the most common aspects that I'm involved in, both with SEC civil matters, but with all other civil litigation, with securities class actions, are the letters rogatory or letters requests for assistance from foreign courts. And that is really a means by which you all as American attorneys can gather information, gather testimony through deposition of witnesses that are resident outside of your jurisdiction. And the slide I set out the 4 conditions that must be met, and really the most important one is that the evidence sought must pertain to the matter before the court, but there's specificity that is required for that. And that is the evidence must be relevant, necessary, otherwise obtainable. And so this is an important tool for you in defending your cases, that there is a lot of times the different relevant players or individuals inside the different financial institutions are available outside the jurisdiction to give that testimony to help defend the matters that you've been involved in. And so that is your 20 minutes of Canadian content. Thank you.